Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today I want to talk about an error in analysis in a Supreme Court opinion, or not an opinion actually, but an oral argument. So I'll have more about that in just a second. So, it's no secret to anybody who knows me that Justice Thomas is, without a doubt, my favorite Supreme Court judge. He is my favorite Supreme Court judge for two reasons. One, he's just a no baloney kind of guy. He doesn't ask questions to pimp the other judges. He asks questions when he asks questions to get information, and it's very rare. Most of the time, he lets the other judges ask the questions, and he just does what he knows is right, which is why I like Judge Thomas. I think he's a brilliant jurist. The only opinion that I can think of that he's ever gotten wrong is the Schindler Elevator case on the False Claims Act, but that's another story. Today, I want to talk, though, about an error in thinking that Judge Thomas made in the oral argument regarding the New York State Rifle and Pistol Association case. Now, for those of you who may have been living under a rock or in a cave in Afghanistan for the last 3 or 4 years, the New York State Rifle and Pistol Association case deals with the fact that in New York, you have to show that you have a need greater than anybody else, than the common public at large, to own and carry a gun in public. And that's not what our Second Amendment says. It's just not. And in fact, Heller interpreted it to say the reason the Second Amendment exists is to allow you to keep and bear arms, which is what the Second Amendment says. So that's not really an unrealistic approach to interpreting the Second Amendment. But I want to put up here just a second the language from the transcript, and I want you to see if you can detect what the error is. Justice Thomas. So, if we look at you mentioned the founding and you mentioned post-Reconstruction. But if we are to analyze this based upon the history or tradition, should we look at the founding or should we look at the time of the adoption of the 14th Amendment, which then, of course, applies it to the states? Okay, do you see the analytical error that Judge Thomas made there? Well, hang on a second. I think I can help you get there. So here is the language from the Second Amendment. Here's what it says. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, all of the conservative justices on the Supreme Court are what are called textualists. In other words, they read the text of the statute or the contract, or in this case, the Constitution, and interpret it based on the words used. So, in order to make this really clear, I want to compare it with the First Amendment. And here is what the First Amendment says. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peacefully assemble and to petition the government for a redress of grievances. Now, if you compare the First Amendment to the Second Amendment, the thing that differentiates them primarily at the beginning is the use of the words, Congress shall make no law. Now, when the 14th Amendment was passed, it was generally thought that that incorporated all of the Bill of Rights to apply to the states. But the one Bill of Rights, the one amendment that it did not need to incorporate was the Second Amendment. Because the Second Amendment says the right of the people to keep and bear arms shall not be infringed. That's the people in the states and it's the federal government. In other words, the state can't infringe on your right to bear arms, and neither can the federal government. If you apply strictly a textualist approach, which is what's called for here, then what you get is the right of the people to keep and bear arms shall not be infringed, and that means all the people, and it means every government from the local municipality all the way up to the federal government. None of those governments may infringe your right to keep and bear arms. So if you take the historical predicate from the standpoint of the Second Amendment didn't actually start applying until post-Reconstruction under the 14th Amendment, in effect what you do is strip out the language that says the right of the people. It is a rather egregious interpretive error from someone who is so smart and so good on the law and such a terrific textualist. Now, Justice Scalia wrote the Heller opinion, and he would never have let Judge Thomas get by with that. He would have talked to him, I'm sure. The fact of the matter is, the right of the people, when that phrase is used, it means all the people. Red and yellow, black and white, it doesn't matter. Gay, lesbian, straight, it doesn't matter what you are. It matters that you are a member of the body politic, the people at large. And for that reason, the right applies to you. So, in my opinion, and again, this is my opinion based on the text of the Constitution, which is what the Supreme Court is supposed to be interpreting, anytime you restrict the right of the people to keep and bear arms, you are in fact infringing on their right to keep and bear arms. So I believe that every state should be a constitutional carry state, and that the only person who should be debarred from the use and ownership of firearms are felons. And the reason is because they have proven themselves dangerous with firearms. They have proven themselves to be a menace to the body politic. It is okay to infringe their rights because at common law, when someone committed a felony, it was a capital crime. And at that time, they took you out to the side of town, found a tall tree, threw a rope over it, and gave you a suspended sentence. So the bottom line is, there is a good reason to deny felons the right to possess arms, because in common law and under the original constitutions of the states, they were not allowed to vote. Assuming that they managed to escape the hangman, they were not allowed to vote again, ever, because they'd shown themselves to not be a responsible member of the body politic. So I have no problem with felons not being able to keep and bear arms. I do have a problem with regular people not being able to keep and bear arms. And of course, Congress has extended the application of the statute to all kinds of things, especially misdemeanors where you can be sentenced to more than 2 years in jail. Well, the problem with that is, and it's obvious when you think of it, a misdemeanor is a much less serious crime. You didn't lose voting rights. And while I understand what they're doing in keeping domestic abusers away from firearms, as far as I'm concerned, every domestic abuse case should be a felony, because no man should ever hit a woman, and no woman should ever hit a man. You should learn to use your words, as they say. Talk it out. But the bottom line is, there can be good reasons to deny certain people who have done bad things the right to keep and bear arms, but there should never be a reason to deny anyone else who is a citizen of this great country the right to keep and bear arms. So I hope you found that interesting or helpful or useful, and if you have, I would really love it if you would give me a big thumbs up. That would tell YouTube that this is good information for other people. And in addition, if you haven't already, please go over here and subscribe to our channel. Tap on the notification bell so you can be notified every time we post a video here on this channel. Thank you so much for watching, and I hope you have a terrific day. I will catch you on here next time.